Okay, we're live on Facebook now.
Okay, thanks, Ika. Right. Okay. Good evening, everyone. Thank you for joining us again for another Thomas Phillip webinar series. As I have indicated previously, we've been doing this since the start of the pandemic, so almost a year now, as a way to reach out to the public, our clients, potential clients, law students, and everyone in between with our contents and any developments in the law which we feel are important for the public. Okay, just a bit of a revision. Starting April onwards, we are reducing the frequency of our webinars. We've been doing it we've been doing it on a daily basis. But moving forward, we're going to do 2 webinars per week in order to maximize viewership and also to make sure that the contents does not get diluted or overlap in between all the various webinars and presentations. Okay, and today is also special because we are actually launching our new newsletter for the firm, and that's why we have this particular webinar today talking about fake news because the newsletter will be done electronically and it will be emailed to all our clients and all those in our email database. So for those who have signed on via Zoom to watch all our webinars, you should be receiving our latest newsletter by today or tomorrow. Okay. So just before I start, just a bit of housekeeping. For those watching via Zoom, please turn off your microphone and turn off your camera to prevent any interference during the webinar. I promise to keep it short and sweet and not bore you guys with unnecessary facts and mundane legal provisions. For those who are watching on Facebook, if you have any questions, you can leave your questions on our Facebook Live page. And if you are watching by Zoom, if you have any questions or any comments, you can leave your comments or questions in our chat section, in the chat section. All right, so let me now share my screen so you can see the slides. All right. Okay, so the topic today is the fake news pandemic. As you guys may be aware, recently, um, apart from the pandemic, the COVID-19 pandemic, we also had instances or a number of instances where you have received news on WhatsApp or email on social media concerning some vaccines, some conspiracy theory, um, toilet papers being out of stock, our supermarkets and our grocery shops do not have any food. So these were common when we started with the pandemic and when we had our first lockdown. So most of it are fake news. Most of it are not true. Most of it were fear mongering by certain irresponsible folks. So I think that's why it's quite apt that we talk about this today, especially in light of the new emergency ordinance, which was passed 2 weeks ago, which caters specifically to fake news during this pandemic or our second lockdown. Right? So just here a brief overview of what I'll be talking about today, COVID-19 and fake news, as per what I explained earlier, and a very brief overview on also the Anti-Fake News Act 2018, which was repealed. This was the previous legislation that we had to deal with fake news. And then we'll talk about Section 505B of the Penal Code, the Communications and Multimedia Act 1998. These are the two existing provisions of, previously that we had to deal with fake news, offensive contents on the internet. And then we'll talk about the Emergency Essential Powers Number 2 Ordinance 2021. And then we'll have a Q&A if there are any questions from you guys. Okay, so let's begin. COVID-19 and fake news, the infodemic. All right, so as I've explained earlier, when we first had the outbreak of coronavirus and people started started getting accustomed to hand sanitizers, wearing masks whenever they go out, some even going wearing gloves, being under a lockdown, staying at home, not working, not going to the office, working from home. So we had all this spate of new activities, new norm, as they call it, the new normal that we had to get accustomed to. And apart from that new normal, part of it also we had this infodemic of misinformation, right? And because of the modes of communication that we have nowadays, WhatsApp, social media, everything is instantaneous, and it has a greater and wide reach. Share something on Twitter, or instantly you can reach 100, 1,000, 2,000, even the whole country. Share something on Facebook, within the next half an hour, everyone can be reading. Suddenly you are trending. I am trending. Whatever keywords in the thread that you share becomes trending. So it creates, I mean, it's good, it's beneficial in the sense that it gives you a very instantaneous mode of communication with far-reaching effects. However, it can also create a negative impact in the sense that it would result in widespread confusion and unnecessary fear. Again, some examples that caused this unnecessary fear and confusion was panic buying that occurred during the MCO because people started saying we have the shops have no stocks, the supermarket doesn't have it, we don't have enough food, we don't have enough rice. As a result, what happened? Everybody started going to the supermarket, started going to the grocery shops, and it was clear. Pictures were circulated on social media, on WhatsApp. People were queuing up hoarding food, getting like six bags of bread, um, boxes of instant noodle, with the fear that they may not have food to eat or may not have sufficient food to sustain them for the next 2 3 weeks or month, as the lockdown was at that time. Or even talking about the vaccine rollout, how the vaccine is not safe, the vaccine is for certain communities not halal, didn't go through the proper process. It's it's a way, it's a conspiracy theory. It's a virus created by China. It's a biological weapon, and everything of those sorts. So we've heard it from A to Z, and of course, most of us are well aware, are well informed enough to do our own reading, but that is not the case for all. As you may all may have aunties, uncles, relatives who are more than happy believing in whatever they receive from WhatsApp, from their neighbors group, from their mothers group, the aunties group, the Taman group. You know what I'm talking about, right? So that's why I think certain legislation on fake news is relevant, especially in light of the panic it could have created during the pandemic. So back then, earlier in 2018, we had the Anti-Fake News Act 2018, which is a law specifically criminalizing fake news. That was repealed in December 2019 as part of the promise made by the previous government. So under this act, those found guilty of spreading what the authorities deem to be fake news could be sent to jail for 6 years and or fined up to 500,000. So it's a very heavy punishment for those who are found guilty to be spreading fake news. Then the act was repealed and it was welcome because a lot of people saw the law as very draconian. The way how fake news was defined and the punishment that entails when you are deemed to be spreading fake news. So a lot of people were happy. This was a victory for freedom of speech. You're allowed to say and share whatever you want without the fear of getting imprisoned or fined by the government. Okay. Obviously, there's always a political element involved whenever it comes to fake news. A lot of people will say that such a law is enacted just to prevent people from criticizing the government or telling the truth about the government. And then after that was repealed, we had two laws, which is Section 505 of the Penal Code and the Communications and Multimedia Act. So these are the next two available options that we had in dealing with fake news after the Fake News Act was repealed. So Section 505B of the Penal Code is for cases concerning spreading fake news during the pandemic, you can be charged under Section 505B of the Penal Code. It covers statements likely to cause public mischief. So if you can see the provision here, what is important is intend to cause or is likely to cause fear or alarm to the public or any section of the public, where any person may be induced to commit an offence against the state or against the public tranquility. So the term public tranquility is quite wide. Intend to cause, that's the operative phrase. Then you must have said something, circulated, published, or made that statement with an intent to cause, or is likely to cause fear or alarm to the public. Okay, and if you're found to have done that, you can be punishable with imprisonment up to 2 years or a fine or both. All right, but there is an exception. Like I said here, the operative key word here is intent. So if you are found to have done this, but you have reasonable grounds, or you can show reasonable grounds for believing that such a statement or rumor or report that you have published, you have circulated, or you have said is true, and then you can be found not guilty under this provision. Okay, that's the Section 505B of the Penal Code. And apart from that, we have a more recent one, which is the Communications and Multimedia Act 1998, the CMA. So this was enacted specifically to deal with abuses or offensive use of the internet. So very specific in nature. It is to govern the use of the internet facilities. Right? It also provides for a number of offences in relation to the use of the internet. One such offence is provided for in Section 211 sub 1 of the CMA, which prohibits a service provider or other person from using a content application service such as WhatsApp, Facebook, to provide content which is indecent, obscene, false, menacing, or offensive in character with intent to annoy, abuse, threaten, or harass any person. Again, there is a couple of things which are important here. There is content which is either indecent, obscene, false, menacing, offensive. Again, rather wide in nature. So the courts and also the DPP who are prosecuting can argue that whatever that is being shared or being published falls into any of these categories because it's quite wide. And with intent, again, there must be an intent to annoy, abuse, threaten, or harass any person. Abuse, harass, or even threaten. I think that's quite clear cut in terms of how do you actually define it. But annoy, again, another very vague and wide term. Anything can be annoying to some people. It's very subjective. For some people, hearing the person next to you eat and chew very loudly, that becomes an annoyance. The sound of a mosquito buzzing in your ears, that becomes an annoyance for some people. For some people, they're quite immune to a lot of things, so not a lot of things would annoy them. So again, it's very wide. One of the criticisms of this particular section. And then we have section 233 of the CMA, which makes it an offence for any person to make, create, or solicit communication via network facilities or network service or application service, which is obscene, indecent, false, menacing, offensive, in character with intent to annoy, abuse, threaten, or harass. Again, similar, but this one is quite specific. Any communication, even to create, to make, or even to solicit via network facilities. So as long as that communication goes via the internet, you can be found to be committed an offence under this act, provided again if it's obscene, indecent, false, menacing, or offensive in character with intent to annoy, abuse, threaten, or harass, similar to the earlier provision. Okay, and as well, apart from that, you can also be found to have committed an offence under this act if you to initiate the communication using any application service, whether continuously, repeatedly, or otherwise, during which communication may or may not ensue with or without disclosing his identity with intent to annoy, abuse, threaten, or harass any person at any number or electronic addresses. So again, the subsection number 2 is to cover people that use fake accounts or anonymity, so without disclosing his or her identity. Okay, So quite clear cut. The first is more specific to a certain application service, and but for section 211, but section 233 is where most of the charges or most of the investigation papers are open because it is very wide. Any communication via network facilities or network service, anything over the internet, anything over your phone line can be governed by section 233. And what about the punishment? So for 211, you can be fined up to 50,000 ringgit or imprisonment not exceeding 1 year and a further fine of 1,000 ringgit for each day of the continuation of the offence. Okay, after that person has been convicted. So if the communication is still there, still remain online, and you still do not take any steps to remove it. So after being convicted by the court, so each and every day of that you are liable to 1,000 ringgit additional. Okay. For section 505 of the Penal Code, again, you can be jailed up to 2 years, imprisonment, or fine, or both. Okay. So then that's the two legislation that we know about, the Penal Code and the Communications and Multimedia Act. And we come to our latest baby here, which is the Emergency Essential Powers Number 2 Ordinance, which I call the Fake News Ordinance. All right, so earlier this year, there was a proclamation of emergency in Malaysia starting from 11th of January to the 1st of August 2021. The purpose of the proclamation of emergency was to ensure that essentially was intended to contain the number of infections, to reduce the number of infections in respect of COVID-19 in Malaysia. Well, that was the line being sold to the public. And then on the 14th of January 2021, um, the first emergency ordinance was passed, which provides for the powers of the YDPA, the powers of the Prime Minister and the relevant Menteri Besar during the emergency. So that's where Parliament was suspended. Government, i.e., the YDPA, can take over properties with the aim or with the objective to combat or reduce infections via COVID. So there are a number of powers, wide powers given to the YDPA and the government to combat COVID during the emergency. I think myself, we have written a number of articles about this, and that can be found on our website and our social media as well. I don't want to go to that because hopefully this emergency will not last much longer. And then recently, on the 11th of March 2021, we had the fake news ordinance, which is emergency essential powers number 2 ordinance, came into effect on the 12th of March. So what is very important, essential, for lack of a better term, about this new ordinance? It makes it a criminal offence for anyone to create, publish, or disseminate fake news relating to COVID-19 or the proclamation of the emergency. So Section 4 of the ordinance provides this. It is stated specifically to make it a criminal offence for anyone to, number one, either create, publish, or disseminate, sharing fake news relating to COVID-19 or the proclamation of emergency. It only covers two things, COVID-19 and the proclamation of emergency. So what is important based on that is how do you actually define fake news and publication pursuant to the ordinance. So if you have a read of the ordinance, fake news is actually defined as any news, information, data, and reports which is wholly or partly false relating to COVID-19 or the proclamation of emergency. And it can be in the form of features, visuals, audio recordings, or any other forms that can suggest words or ideas. So again, very wide. It need not be in black and white. It can cover videos, audio visuals, memes as well. I'm sure if memes are covered under this fake news ordinance as well. And what amounts to publication, written or similar to written, and every copy and reproduction of such publication. Each and every copy and reproduction is a fresh publication. and digitally, electronically, magnetically, or mechanically produce publication and replication of such produce. Essentially, everything under the sun. Online, print, and whatever other media you can think of. Okay, so it covers that is how fake news in publication has been defined under this new ordinance, right? So what are the elements of the offense? So there must be intention to cause or likely to cause fear or alarm to the public, or it creates, offers, publishes, prints, distributes, circulates, or disseminates fake news or publication containing fake news. So there must be an intention to cause, or you know that such a publication is likely to cause fear or alarm to the public, right? So it covers, or it is applicable to someone who creates, offers, publishes, prints, distributes, circulates, or disseminates the fake news. So that's the elements of the offense, and the fine and the punishment upon conviction: fine up to 100,000 ringgit, imprisonment up to 3 years, or both. All right. The court can also order for an apology to be made to the person affected by the offense. So if there is an order for you to make an apology but you fail to comply, you will be liable to a fine of not more than 150,000 or imprisonment of not more than a year, or both. This is over and above the earlier punishment. So it also covers situations where there is some direct or indirect involvement by third parties other than the wrongdoer itself. So not just the maker of the statement, the publisher of the statement, a third party can also be charged under the ordinance. So institutions that act as financial backers, provides financial assistance, intending to commit or facilitate the offense of publishing fake news, can also be fined up to 500,000 or imprisonment up to 6 years or more. So anyone who acts as financial bankers or provide financial assistance to those intending to commit or facilitate an offense under this act, under this ordinance, can also be fined and imprisoned, as you can see here. And it also includes representatives of companies, body corporates such as CEOs, directors, managers, secretary, who can also be made liable if their employees are charged and if the offense committed by the employee is in the course of employment or acting on their behalf. So if you have employees who are trigger happy, keyboard warriors, beware that you can also be charged as an employer, or as a director, as a manager, or a CEO of that particular company in the event that employee is charged under this ordinance. So the ordinance also empowers the authorities to prosecute individuals who are overseas if the offence was committed in Malaysia, or the citizen or the publication concerns or affects Malaysia or Malaysian citizens. So again, it tends to give the authorities wide powers, so even people who are overseas can be charged under that offence, as long as the offence was committed or the publication was done in Malaysia and it affects or concerns Malaysia in general, or a Malaysian citizen. So that's the additional impact uh, for this ordinance. Apart from the earlier legislation I've talked about here, even third parties who is somehow directly or indirectly involved in that offense can also be punished with a fine or also imprisonment. And one additional part to this particular ordinance is that you can apply for a court order for the removal of fake news publication. So who can apply? Anyone who claims to have been affected by fake news. So again, just to remind everyone, fake news here is fake news concerning COVID-19 or the proclamation of emergency. Okay, whoever that claims to have been affected by the fake news can apply to court with no notice to those who wrote or posted the material for an order to remove the content. So as you can see, you don't even need a notice. So if I have published something and someone claims to be offended by it, they can go to court directly without notifying me and ask for an order for the same to be removed. How do you apply? Fill out Form A of the schedule. So the ordinance provide provide a form and you provide a police report and other relevant documents. Of course, this has yet to be tested in court yet. So the actual manner, whether you do this or do you go by a notice application, or you initiate a fresh action, so that hasn't been tested yet. And but in terms of the ordinance, this is what they provide. And notice of the order can be served electronically, including by sending it to the person's social media account or email address, other than by personal service or post or to last order. So interestingly, I believe this is one of the first legislation in Malaysia that allows you to serve a court order by sending it to a person's social media account. How groundbreaking is that? I must say that part I gotta give credit to whoever that drafted this. So that is brilliant. You're allowed to actually serve court papers in particular in this case the court order by way of social media. So I think that is that has to be applauded. I think that has to be taken into account as a possible mode of service moving forward. I mean, I do a lot of defamation cases, and it is quite clear that the number of cases involving defamation by social media has been constantly increasing over the last decade. So it makes sense to actually allow certain court papers to be served via social media. So if there is an order for you to remove that fake news or the offensive publication, if you fail to comply, you can be fined up to 100,000 ringgit. And the court may also allow the police to take any necessary measure to remove such publication upon application by the public prosecutor. So if you are the recipient of such an order, you can file an application to set aside within 14 days from the date the order is served on him. There is an exception. You cannot apply to set aside, or such an application will not be allowed if the publication is prejudicial or likely to be prejudicial to public order or national security. Here we go, another very subjective, very vague, wide terms being used in the ordinance. If the publication is prejudicial or likely to be prejudicial to the public order or national security, then you cannot apply to remove, you cannot apply to set aside the order to remove the fake news. So what happens if you are found to be guilty and the offense still continues? So if the publication still remains online or wherever that you have posted it, you're liable for a further fine up to 1,000 ringgit each day after conviction. And under Section 6, there is a duty to remove. You must remove the publication within 24 hours from the time a direction was given by a police officer or an authorized officer. You need not wait for a court order. If a police gives a direction or instruction to remove the publication under this ordinance, you must do so within 24 hours. Failure to do so, another fine, 100,000 ringgit. So again, if you have been notified by an officer to remove and you fail to remove, you'll be liable to a fine of RM 3,000 ringgit each day of the offense. Okay, the continuing offense. So that is how the offenses work and the punishment available under the ordinance. So now we look into what powers does the police and the public prosecutor have under this ordinance. Okay, so they are given power to arrest any person whom they reasonably believe have or is attempting to commit the offense, and it requires the individuals, corporations, social media platforms to give the police access to traffic data and computerized data upon request if the traffic data is reasonably required for investigation and there is a risk that the traffic data may be destroyed or rendered accessible. And what does this data mean? Password, encryption codes, decryption codes, software or hardware, or any other means required to access the data. If you fail to provide the data, again, you are liable to a fine of up to 100,000 or imprisonment of not more than a year or both. So apart from allowing the police to offend someone whom they reasonably believe to have committed an offense or is attempting to commit an offense under this ordinance, The ordinance also allows or makes it mandatory for any individuals or corporations to provide electronic data, traffic data, including passwords, encryption codes, and encryption keys or software and any hardware for the purpose of investigation under this ordinance. So as you can see, again, very wide-ranging powers. You're more or less giving away all your data, including your password, your encryption code, decryption code, all will be given to the police if they have reason to believe you have committed an offense under this act and they are required to investigate further. Again, if you don't provide that data, it is an offense and you can be imprisoned for up to a year and fined up to 100,000 ringgit or more. So quite onerous. Wide powers are given. It is imperative that I think, as you can see, number one, persons, third parties who are directly or indirectly affected can also be charged under this ordinance. And now, you are also required to give access. So this includes companies where the accused is looking at the social media platforms. So again, um, it could be time for companies to may be supervising. You may need to supervise your employees a lot more if you know of any employees who have a tendency to share things which may be prejudicial or may be classified as fake news under this ordinance. Those, like I said earlier, those keyboard warriors, those who likes to share news on social media or WhatsApp. So companies may have that additional burden to monitor in light of these additional provisions under this ordinance. Okay, so that is my presentation for today. So I'm just going to highlight a little things. So this is going to be just a bit of recap. So from the start of the pandemic, from the start of our first lockdown, I think everyone here, we've encountered a number of fake news regarding, like I said, stocks of food, government's decision, why the lockdown was done, etc. And certain news, certain fake news or untrue news would have led to certain amount of public panic, public confusion. So there may be, there, I would say it may be warranted to have certain legislation to govern the spreading of fake news during the time of this pandemic. So to prevent any infodemic, is what I suggested earlier. And we had the Penal Code and the CMA, which provides for a number of offences to prohibit or to govern or to make it an offence for those that are publishing fake news. Um, then we also had recently the fake news ordinance, which, as I have highlighted earlier, um, it was it was drafted to combat, or it was shown to us to have combat fake news in respect of COVID-19 or the proclamation of emergency. So it's very specific in nature and it is enforced as long as the emergency is enforced. And there are wide powers given to the police, to the public prosecutors, and even the offences could impact and also touch on third parties who are indirectly involved. So again, as you can see why I think a number of people were quite concerned with this ordinance, and also the fact that the burden of the evidential burden is actually in favor of the prosecutor if you look through the ordinance. So I think you can see this progression involved from the existing legislation that we had, and then I think circumstances dictate why the fake news ordinance had to be legislated and why it was necessary for the powers that be to impose such requirements. I think as far as I'm aware of, no one has been charged under that ordinance yet, but it will make for interesting times up ahead to see if anyone is charged under the ordinance, and also the potential legal challenges involved, where the court will be required to actually determine the definition of fake news, or the manner in which a party actually applies for an order to remove the fake news or the offensive articles. So yeah, I mean, we are living in interesting times. People have different opinions on whether the fake news ordinance is necessary or is an overkill, but it is what it is. That's what we have at this moment in time. So I think, I mean, we all have our own views. I feel that Penal Code and the CMA is sufficient, but what I think is not very important, clearly. But yeah, so for those of you that are very trigger happy, sharing things on Facebook, Twitter, WhatsApp, do read the ordinance one time or two times at least before the next time you press that share or like button. It may just cause you or lead you to be imprisoned or fined 100,000 ringgit. Okay, so let's see whether we have any questions. Okay, sounds like yes. Okay, sounds like company needs to implement policies ASAP to prevent. Yes, I agree. I think with the how the ordinance was drafted, I think there is some sort of a training or policies involved that companies must put in place to prevent such offences, of to prevent the companies or the people in the company from being brought to the court as third parties for acts done by their employees. I think yes. Apart from I think just not just employees, not just companies. I think a number of organizations wherein you have people involved. Either it could be a government body, a statutory body, it could be anything. So I think it is important that people do understand the nature of this ordinance and the severe consequences involved, not just to the person sharing or making that fake news, but to other persons who may be indirectly involved either by way of being employers or co-workers or financiers, etc. That's the ordinance today. So okay, I just answered your questions. Ika, any questions on Facebook?
We don't have any on Facebook.
Okay. So if there are no other questions, so, thank you. I mean, you can leave your comments, or if you can think of any, if you want to have any other questions, you can drop me an email or leave that comment or questions on our Facebook page, and we will try to respond to you as soon as possible. If there are no further questions, thank you for joining us tonight. Stay safe, and again, like I said, do follow us on our social media and on our Facebook and LinkedIn account, where we will be updating everyone on our upcoming talks. And I think we are doing our updates on a weekly and also on a monthly basis. And also, if you're interested to receive our new newsletter. All right. So thank you very much. Have a good evening, good night, and stay safe. Thank you. And don't share fake news.